As stated previously, the doctrine of stare decisis is not law. It's not found in the Constitution. It is a custom, a tradition, a rule of judicial philosophy that justices use in order to stabilize, in my mind, legitimatize decisions to be made on current controversies. Since judges' decisions are made in secret, when I say secret, I mean they're made in their chambers. It's not like they have a debate on how they're going to have a decision. They may divide in the Supreme Court. The giant justices will get together and they will debate with each other. But when they make a decision of how they're right, they're making it on their own. They're made in this secret, and they're made this in their chambers. It's based on each judge's consciousness interpretation of the previous laws, court decisions, and facts of the case before him. This could lead to sudden changes in law not anticipated by the public. This change in the law may not be understood and may have changed what the people thought the law to be. Many of SCOTUS, Supreme Court decisions, are made 5-4. That means that just one justice vote swings the decision one way or the other. As a law professor, when I teach this to the students and they ask me what is the law, I says I don't know what the law is. It depends on who's swinging. If 4 Supreme Court justices look at it one way and 5 looking at the other way, well, I mean they both have their reasons, but 5 judges are more than 4 judges, and that's what makes the precedent. But sudden changes in the law are not favored, as the public will lose faith that the decisions are being made by the rule of law rather than the opinion of a man. Each case before the Supreme Court is different in factual evidence, even if they have common principles from which the court must determine how the Constitution or a law applies to that set of facts. Stare decisis is the preferred action by the court. As stated by the Supreme Court 1991 decision, stare decisis is the preferred course because it promotes the even-handedness, predictability, and consistent development of legal principles. It fosters reliance on judicial decisions and contributes to the actual and perceived integrity of the judicial process, unquote. However, each judge has a different position on when this principle should be abused. Justice Roderick, who is the Supreme Court Chief Justice at the moment, stated during his Senate confirmation hearings in 2005 the following, quote, "I do not think that it is a jolt to the legal system when you overrule a president. Presidents plays an important role in promoting stability and even-handedness," unquote. He also made the following very pertinent statement, quote, "For the court to overturn a prior decision, it is not sufficient to believe the case had been wrongly decided. Justices have to consider other factors too, like settled expectations, like the legitimacy of the courts, like whether a particular precedent is workable or not, when the precedent has been eroded by subsequent developments," unquote. Justice Samuel Alito stated in his confirmation hearings before Congress in 2006 that Roe v. Wade was an important precedent of the Supreme Court. Roe v. Wade is Roe v. Wade is an important precedent of the Supreme Court. It was decided in 1973, so it has been on the books for a long time. It has been challenged, it has been reaffirmed, unquote. Judge Clarence Thomas declared during his confirmation hearings in 1991 the following, quote, "I think those of us who have become judges understand that we have to begin to shed the personal opinions we have. We tend not to express strong opinions so that we are able to, without the burden or without being burdened by those opinions, rule impartially on cases," unquote. Justice Gorsuch stated during his confirmation hearings in 2017 the following, quote, "I would tell you that Roe v. Wade, decided in 1973, is a precedent of the United States. It has been reaffirmed. A good judge will consider it as precedent of the United States Supreme Court, worthy as treatment of precedent like any other," unquote. he stated, Roe versus Wade is the law of the land. I accept the law of the land, Senator, quote, he said. Justice Brett Kavanaugh stated in his confirmation hearings in 2018 as follows, Roe versus Wade, quote, it is settled as a precedent of the Supreme Court. Entitled to respect on the principle stare decisis, the Supreme Court has recognized the right to abortion since 1973 case and has been reaffirmed many times, unquote. Justice Amy Coney Barrett stated in her confirmation hearings in 2020, acknowledged stare decisis and Roe versus Wade as a precedent, however stated, quote, Roe is not a super precedent because calls for its overruling has never ceased, but that does not mean that Roe should be overruled, unquote. Yet despite these assertions by all 6 justices, in the case of Dobbs versus Jackson Women's Health Organization, decided in 2022, all justices voted against Roe versus Wade and the established precedent of Roe versus Wade. These justices disregarded stare decisis and decided that Roe would no longer be the law of the land. So it seems, the stare decisis is important only when the judges decide that it applies. So what is a super precedent? Justice Amy Barrett stated, quote, a super precedent are cases so well settled that no political actors and no people seriously push for their overruling, unquote. Professor Michael Gerhardt, one of the books that I use, textbooks I use, stated, who is an expert in constitutional law, defines super precedent as follows, quote, super precedents are those constitutional decisions in which public institutions have heavily replied and consistently supported over a significant period of time. Super precedents are deeply embedded in our law and lives through the subsequent activities of other branches. Super precedents seep into the public consciousness and become a fixture of the legal framework, unquote. Thus now that Roe versus Wade has been overturned by the courts, it appears to have changed settled law. All the justices of the Supreme Court had agreed that Roe was settled law. How is this decision then to be justified to the public? The fact that we now have barricades around the Supreme Court is a testament that something has gone wrong with the stability of the court as it is perceived by the public. Apparently, Roe versus Wade was not a quote-unquote super precedent. Now, Justice Roberts, while acknowledging that precedents are important, indicated that the justices must also look at other factors as stated above. A well-known decision of Brown versus Board of Education back in 1954 that decided that segregated schools was unconstitutional by the Supreme Court. That decision has been hailed as one of the greatest Supreme Court decisions. Despite the fact that the court overruled 60-year precedent of Plessy versus Ferguson, in that case that was decided in 1896, Plessy indicated that the public schools were a state matter and the states were free to do with their schools what they desired, including segregating the schools. No one from the NAACP who litigated the case before the Supreme Court was able to point to any precedent that established the right to desegregation in the federal Constitution. Yet the court ruled 9-0 in the Brown versus Board of Education case and decided that the old precedent would not be justified and a new standard had to be imposed by the federal courts about the state school system. This may have been the more right thing to do, even if not previously legally acceptable, if you applied stare decisis. Thus, in the case of Brown versus Board of Education, the court decided to ignore stare decisis of the Plessy case and decided to desegregate schools, and they too ignored stare decisis. So what we have is two examples of the courts ignoring precedent, one from the left and one from the right politically, because they had the majority with which to do it. So how does a court decide when to impose a precedent and when it is inappropriate to disregard the precedent? The answer to that question is the subject matter of these courses and these classes. The Supreme Court, by its reasoning, has developed many ways to test whether law is unconstitutional or not. Let's remember that only the Supreme Court can decide if a law, whether it's state or federal law, runs afoul of the United States Constitution. In order to give guidance to lower courts, legislators, and to lawyers advising their clients, the Supreme Court over the years has developed a series of doctrines of interpretation. These doctrines or tests help to reach a decision about how or what is constitutional or unconstitutional. Using these tests, the courts or legislators can determine if the law clashes with the Constitution. Let's start with the simplest test that the court will use when faced with a challenge to a specific law. That is called the rational basis test, and that is stated as follows. Quote, a law is entitled to a strong presumption of validity. That means the court will start off believing that the law is valid unless the litigant can show that there is no rational basis for the law. If no rational basis exists, then it will collide with some right that the litigant is claiming. The rational basis test prohibits the government from imposing restrictions on liberty that are irrational or arbitrary or drawing distinctions between persons. So long as there is some rational reason that the legislature determines that they need to restrict some right, the court would uphold the law. For example, the right to seek a medical doctor's license. The state can regulate how doctors are licensed, the requirements for licensing, education, etc. Thus, a state regulation or law on doctors having a license from an accredited medical school would not be considered a violation of the rights of a person seeking to be a doctor who came from an unaccredited medical school. The court would use the rational basis test to rule that the state legislature has a rational reason for imposing these requirements because the state wants to have doctors of only highly regulated and qualified schools. This will be a rational reason, and thus, while limiting some doctors from a foreign country from obtaining a license, the court would not rule this restriction to be unconstitutional. However, when a right that is being regulated is a fundamental right, quote unquote, then the court will use a much higher standard. This higher standard is called the strict scrutiny test. Wikipedia summarizes this test as follows, quote, when a law infringes upon a fundamental right, the court may apply a strict scrutiny standard. Strict scrutiny holds that a challenged law is presumptively invalid unless the government can demonstrate that the law or regulation is necessary to achieve, quote, and compelling state interest. The government must also demonstrate that the law is, quote, narrowly tailored to achieve that compelling purpose and that uses the least restrictive means to achieve that purpose. Failure to meet this standard will result in striking the law as unconstitutional, unquote. So there's a lot to unpack in there, but you'll have to get the book in order to get more material. But I'll try to explain. When a right is a fundamental right, requiring the application of strict scrutiny, this is when the subject of the following cases which I have selected in order to demonstrate how the court makes a decision one way or another. It's a lot that has to be determined. Now we're going to go into individual rights.